First, I am not an attorney. This should not be considered legal advice. Secondly, this is a listing agreement for the state of Tennessee. If you live in a different state, your listing agreements could be slightly or even drastically different. And lastly, before we get into this video, there are several things in this listing agreement that can be considered repetitive that I just want to quickly cover now, so we're not spending a lot of time covering them throughout this video. You agree to fill out the disclosures and disclaimers accurately, and that is your responsibility, not your listing agent's responsibility or the brokerage. Secondly, that you allow the listing brokerage and agent to market your property on the multiple listing service or MLS. You give the listing agent and brokerage permission to put a sign in your yard and a lockbox on the property for buyers' agents to access the property to show potential buyers. It talks a lot about who real estate agents are and who they aren't, such as we are not property inspectors, appraisers, surveyors, attorneys, anything of that sort. We are real estate agents. It talks a lot about the real estate agent's duties to you, and commission is mentioned several times as well, which we will touch on in this video. So as I said before, this is a listing agreement for the state of Tennessee, also known as a RF-101. So the listing agreement starts on line 1, and this is where the name of the company that you're listing your property will be listed, which if it were me, that would say Seven Lakes Realty. Line 2 would have the address of the company. Line 3 would have your name, the seller, and line 4 would have your mailing address, and I'm sure that has to do with tax purposes because when you sell a property, you have to pay sales tax on that, and I'm sure typically they'll mail you a 1099 in the mail after selling the property. If you scroll on down on line 8, you get to the legal description of the property, which is the address, the city, the county, zip code, all of that. And then it also has the deed book and the deed book page that your deed is recorded in. It asks for the page number. And then on line 13 and 14, you see that long blank there. There's a couple of different things that could be listed there. Typically what I put is the map number of your property and the parcel number again, but you could see subdivision name with lot number there. There are different things that I've seen on this line here. Typically for me, like I said, it's always map number and parcel number repeated there. Line 16 under A, it talks about what will be included in the property at no additional cost to the buyer. Things like window blinds, light bulbs, ceiling fans, sink faucets, all of that, what you're leaving with the property. It asks if there's a garage on it, how many remotes will you be leaving with the garage. Line B, if anything is mentioned above that isn't in that whole paragraph there, you could write it in right here. Sometimes you would write in appliances here, a shed, if there was a shed in the backyard or something along those lines, trampoline, whatever, you could write it there under B. Line C, it says items that shall not remain with the property. Typically what I put right there is any personal items of the seller. Line D, it talks about leased items with the property. It gives examples of security systems or water softener systems. Another good example would be if your property runs off of natural gas and you have one of those big propane tanks that you're leasing out. That's a common thing that you can see there. But more times than not, it typically is left blank because most people, at least in my area, don't lease items for their property. But if they were to, there's an option for it right there. Line 37 talks about the listing price. This is the price that your real estate agent and brokerage is going to market the property for. That could say $1 million. It could say $500,000. It could say $100,000. It could say $10,000. Just whatever you were trying to sell the property for, that's where you would put it right there. Line 39 says through, which is a listing expiration date. How long does the brokerage and listing agent have to market your property? There would be a date there, and once that date concludes, they will no longer be marketing your property if it does not sell. Line 42, you see it in big bold letters. It says marketing property commencement date. Typically, that is the date that you sign this agreement, or say you need to get something repaired or get the property cleaned up before the pictures. On line 46, you would check that box and then enter in the date that you want the property to be started being marketed. So if your real estate agent looks at the property on the 1st and you need a week to get it cleaned up and things repaired, they would check that box there, and the real estate agent and brokerage would start marketing the property on the 7th. Line 47 talks about the carryover clause. So if this agreement expires and just say a buyer contacts your agent and says, hey, I seen that property on the market, I was interested in it, and I would like to buy it now. I wasn't in a position to buy it before. That carryover clause is how long that this agreement is good for after it expires if the real estate agent or brokerage happens to find a buyer within that time. Typically, I put 30 days there, but you could see 60, 90, or 180, or even up to a year. It just all depends on your listing agent and the brokerage. That would be a good question to ask them during the interview process when you're interviewing real estate agents for the sale of your home. Line 54, possession of property to be delivered. This is when the buyer will take ownership of the property. I always write in there at closing. Line 5, terms of sale acceptable to the seller, such as FHA, VA, conventional, etc. This is what types of mortgages are you happy with the buyer receiving to purchase your property. I always put FHA, USDA, VA, conventional, cash, and other. That way, as long as the buyer has the funds to purchase the property, usually it doesn't really matter how they're going to purchase it. I mean, if we have multiple offers and one is offering cash and the other one's offering some type of loan that could be a headache, obviously the cash offer would get priority if the monetary amount is the same. But as long as the person has access to the funds, that typically doesn't matter to most sellers. Line 57, number 6 here, it says seller concessions. This is just to let you know that the buyer can ask for anything they want to in their offer. Maybe you don't want to leave your appliances or furniture at the property. The buyer may ask for you to leave those. Maybe there are some repairs that need to be done when you were planning to sell the property as is, and the buyer includes in their offer that you to have them fixed by the closing date, and then that is totally up to you whether you want to do it or not. You can accept it and do it, or you could say no, and then the buyer would have the option to buy it anyway or walk away as long as it's still passed for their mortgage. Line 60, number 7 here in big bold letters. So back in August of 2024, and if you're watching this video, you probably already know about the lawsuit that I'm referring to, but it says in big bold letters, broker compensation is not set by law and compensation rates are fully negotiable. That got added into all of these listing agreements after that whole lawsuit went through. And then even whenever we had properties that was on the market at the time, we was required to do an amendment to our listing agreements, and they made a special document for that. I forget what RF number it was, but it just said that statement in big bold letters, and we had to have our sellers and buyers and all of that sign off on that in order to keep doing business with them. So line 62 talks about the compensation to the broker. This is what you're going to pay them to sell your property. So this first blank here with the dollar sign in front of it, if they are charging you a flat fee, that flat fee number would be there, such as $20,000, $10,000, $5,000, $1,000, or even $500, excuse me. Or there may be just a line or a slash through that blank there, and it says or a percentage amount. So it could be 8%, 6%, 4%, 2%, 0.5%, whatever percentage they put there, that would be the percentage. Line 68 talks about cooperating compensation. So this is if you're paying a buyer's agent brokerage, you're signing off that you agree for the listing agent, listing brokerage to split the commission with a buyer's agent's brokerage. And you don't have to do this. That's one of the big things that whole lawsuit was about. Now, I highly recommend that you do, because if you don't, it's up to your listing agent and listing brokerage to sell the property all on their own. Whereas if you offer a percentage amount, that opens you up access to all the other agents in your area, especially the buyer's agent in your area, to start showing their clients. Now, a whole other video that I plan on doing in the future is the buyer-broker representation agreement. And that agreement has a section in there talking about where if you, the seller, does not agree to pay the buyer's agent fee, buyer brokerage fee, that the buyer is responsible for doing that. But I can tell you now, at least in my area, most buyers do not have cash in hand to pay for representation. And according to the mortgage lenders that I work mostly with, that is not something that they are able to bundle into their mortgage at this point. Line 72 talks about if you were to lease the property, how much would you pay the listing agent and brokerage if you decide to rent the property out? Now, I always just put a slash through the flat mounted part and put an X on the percentage part, because I don't charge people to do that. Typically, if I'm selling a property, the seller wants to sell it, they don't want to rent it out, they're not willing to deal with the headache of renting out the property. Then 92 talks about the responsibility of the parties. We kind of touched over that in the beginning. Line 128, number 9, Foreign Investment in Real Estate Property Tax Act. Disclosure. Seller is hereby notified to consult with seller's own closing attorney and tax professional concerning the applicability of Foreign Investment in Real Estate Property Act, which may require tax withholding to be collected from seller at the closing of any sale of the property. Examples of this may include if seller can be classified as one of the following: non-United States citizen, non-resident alien, or foreign corporation, partnership, trust, or estate. It is the seller's responsibility to seek independent tax advice prior to any closing date regarding such tax matters. Again, number 10, it's talking about that you agree to fill out the disclosures and disclaimers and all that. And then it goes into talking about who the real estate agent is and who the real estate agent isn't. Then it goes into talking about the real estate agents and brokerage's duties to you, the client. D here on line 260 talks about who the brokerage is appointing to represent you in the real estate transaction, which typically, at least here where I'm from, I go out and get all of my own business. So that would be my name there in that blank. And then it talks about how the brokerage may take me off of your representation and put in another agent there if I'm not doing my duties, or if you was unhappy with the service I was providing. It talks about if I were to find my own buyer, which I do 40 to 50% of the time, which is a really good number considering the national averages, that I would default to a facilitator or a designated agent for both parties, which would be disclosed. Line 13 talks about earnest money. It talks about you're authorizing the broker to accept buyer's earnest money deposit and put it into an escrow account. Line 14 talks about the title. Seller warrants seller is vested with good marketability of title to the property with full authority to execute this agreement and sell the property. Seller shall convey property by good and sufficient general warranty deed. Line 15 talks about a home warranty. If you're going to put a home warranty on the property, you would check that box and enter in how much you're willing to spend on it and what company you plan to do the warranty through. Or on 293, you would just check the box saying home protection plan waived. Then it talks about how this is a legal document and is binding by law. Number 17, line 314, legal document. This is an important legal document creating valuable rights and obligations. If you have questions about it, you should review it with your attorney. Neither the broker nor any agent or facilitator is authorized or qualified to give you any legal advice about the advisability or legal effect of its provisions. By signing this document, you are certifying that you have read and accept the terms and acknowledge receipt of a copy of this agreement. Line 18 talks about confidentiality. Of course, we have, as a brokerage and a listing agent, we have, part of your personal information that you probably wouldn't want disclosed. I typically leave that blank because I don't ever disclose any confidential information. But if it was ever okay with you for me to disclose confidential information, whatever that information would be, we would type in on number 18 there. Line 19 talks about exhibits and addenda. This is if, there was something extra with the property. Typically, if a house is on one parcel and you own another parcel right beside it that you're selling with the property, that parcel number and all of that would be typed in there. That's what's most common for that. Line 20 is a special stipulation. So this is if anything above was left out, it would be typed in here. And in most cases, my brokerage doesn't charge a transaction fee. I don't charge a transaction fee, but many brokerages charge transaction fees, and the transaction fee would be in this box here, whether that be $100, $500, $1,000, $5,000, whatever the amount would be. The special stipulations here on line 331 is where you would find that. You scroll on down, and then your listing agent would sign, print their name, and then it would have the name of the company. And then you, the owner, and the seller would sign as well, and it would be dated, and then we would have a listing agreement. So we talked about in the start of the video that you agreed to fill out all the disclosures in the listing agreement. So this is the long property disclosure. This is the RF201, and this document would be uploaded to the MLS for any potential buyers to read and review and go over before touring the property or before even offering on the property. So line 1, again, it talks about the address of the property, where it's located, your name, the age of the property, and then the date you acquired the property. It would then ask, do you occupy the property? That would be yes or no. If not owner occupied, how long has it been? And you would answer how many years it's been since you lived in the property. Line 5 is this a site-built home or a non-site-built home? So is it a site-built home, they come to the location and built the house, or is it something like a mobile home or a tiny home that was built somewhere else and then moved to the property? So line 71 says the subject property includes the items checked in the box below. And then you would go through and you would check all the boxes for anything that is going to be included with the property, such as a range, window screens, microwave, oven, a hot tub, pool, just anything that's going to be included with the property would be checked on these boxes here. 85 asks about the hot water heater. Is it electric, gas, or solar? Is there a garage? Is it attached, not attached, or is it just a carport? How do you get your water, your gas, your sewage? It talks about what type of roof you have and how old the roof is. If you wouldn't know, I typically put, for instance, I would put on line 90, it's a shingle roof. You don't know the age, so I would put unknown. Or if you do know the age, hey, I got that roof 5 years ago, so the roof is 5. So if you know it, you put in there. If not, I would just put unknown on that box. And then line 92, underneath that's a long blank there. If there was anything that was failed to be mentioned above, you could type that in, what is also going to be in the property. Line 95, to the best of your knowledge, are any of the above not in operating condition? You would either check yes or no. If you checked yes, you would specifically answer what is not in working condition and describe what's going on with it if you know. Line 100, are you, the seller, aware of any defects or malfunctions in any of the following? Interior walls, ceilings, floors, windows, doors, insulation, slab, driveway, central heating, roof, basement, all of this. And you would either check yes, no, or unknown. Line 112 there, if you answered yes to any of it, you would explain what is the problem. Line 113, C, are you, the seller, aware of any of the following? 1. Substance, material, or products which may be environmental hazards, such as but not limited to asbestos, radon gas, lead-based paint, fuel or chemical system tanks, contaminated soil, and or water on the property. Yes, no, or unknown. Number 2. Features shared in common with adjoining landowners, such as walls but not limited to fences and or driveways with joint rights and obligations for use and maintenance. 3. Any authorized changes in roads, drainage, or utilities affecting the property or contingent to the property. Any changes since the most recent survey was done, and then you would enter the date of the most recent survey. Any encroachments, easements, or similar items that may affect your ownership interest in the property. Rooms, additions, structures, modifications, or other alterations or repairs made without necessary permits. Rooms, additions, structural modifications, or other alterations or repairs not in compliance with building code. Landfill on the property or any portion thereof. 9. Any settling from any cause or slippage, sliding, or other soil problems. 10. Flooding, drainage, or grading problems. 11. Any requirement that flood insurance must be maintained on the property. 12. Property or structural damage from fire, earthquake, floods, or landslides. If yes, in the box below, you would enter in what was the issue. And on line 141, if yes, has said damage been repaired? 13, is the property serviced by the fire department? If yes, you would enter in which fire department is servicing it on the line below. Line 146, is the property owner subject to charges or fees for fire protection, such as subscription service? You would enter yes, no, or unknown. 14, any zoning violations, non-conforming uses, or violations of setbacks requirements. 15, is there a neighborhood noise nuisance problem? 16, subdivision and or deed restrictions or obligations. And then 17 goes into talking about if you live in an HOA and given the HOA's information. If you do not live in an HOA, then you would just leave that part blank. At least that's what I do. 18, is the location of the property within an improvement district that is subject to special assessment? And then right under it says a rate of special assessment. 19, any common area facilities such as but not limited to pools, tennis courts, walkways, or other areas co-owned in undivided interest with others. 20, any notices of abatement or citations against the property. 21, any lawsuits or proposed lawsuits by or against the seller which affects or shall affect the property. 22, is any system or equipment part of the property being leased? If yes, again, you would explain below. 23 asks if any exterior part of the property is covered in synthetic stucco. And then it says on line 176, the Tennessee Real Estate Commission urges any buyer or seller who encounters this product to have a qualified professional inspect the structure in question for the proceeding concern and provide a written report of the professional's findings. If yes, explain what is covered in stucco, synthetic stucco. And then at line 182, number 24, so there's a couple of different types of property disclosures. If you've not lived in the property, typically is the most known reason that I run across. If you've not lived in the property for 3 years, you don't have to fill out all the above. You just have to fill out what is on line or number 24 and going down. There's a whole list of reasons. We won't get into that in this video, but the most common reason I see is because the owner has not occupied the property within the last 3 years, but they still have to fill out from 24 down. It's just on a smaller document, which is a RF 203. But line 24, it asks, is there an exterior injunction well on the property? 25, is the seller aware of any percolation tests or soil absorption rate being performed on the property that are determined or accepted by the Tennessee Department of Environment and Conservation? If you answered yes, their findings will be attached to this document. 26 asks if any part of the property has been moved from its original foundation. If it has, obviously you would put it in the blank there underneath line 188. 27 is a property in a planned unit development. Planned unit development is defined and pursuant by Tennessee Code 66-5213 as an area of land controlled by one or more landowners to be developed under unified control or ununified or unified plan of development for a number of dwelling units, commercial, educational, recreational, or industrial uses, or any combination of the foregoing, the plan for which does not correspond in lot size, bulk, or type of use, density, lot coverage, open space, or other restrictions to this existing land use regulations. Unknown is not permissible answer under this statute. So that would just be yes or no. Were you and your neighbors planning to build an amusement park on the property or farm it or whatever? So that would just be a yes or no question there. 28, has there ever been a sinkhole on the property? A sinkhole is defined pursuant to Tennessee Code 66-5212C as a subterranean void created by the dissolution of limestone or dolostone strata resulting from groundwater erosion causing a surface substance of soil, sediment, or rock, and indicates through the contour lines of the properties recording plot map. This disclosure is required regardless of whether the sinkhole is indicated through the contour lines on the property recording plot map. Then line 29 asks, was there a permit done for the septic tank if it has a septic tank? A lot of older properties may have septic tanks, but you talking back in the 70s and 80s, there may be a permit, there may not have been. We try to find them. If we can't find them, we just leave that blank. If we can find them, we put yes, and we'll usually attach that permit along with this document. Or if you have city sewer, then you just leave it blank as well. D, certification. This talks about that you certify that all the information is correct, and it would have the property address listed below. Then you, the seller, would sign it, and then the buyer would also sign it saying that they've seen it, which kind of covers you in the future. The last document we're going to go over today is the lead-based paint disclosure, which is an RF 209. This is a federal law stating that any house built before 1978 has to have a lead-based paint disclosure signed by both the seller and the buyer from transfer of ownership of the property. And it talks about the harms that lead-based paint could do to you and your family. Line 13 is the address of the property. Line 17 and 19. So 17 says that you know about lead-based paint in the property, and you would describe it there on line 18 of what you know about. Line 19 says that you have no knowledge of lead-based paint in the property. Line 22 says that if you have documentation showing that there's lead-based paint in the property, you will give that to the buyer and attach the documents and kind of describe what's in there on line 24. Line 25, you may know of lead-based paint being in the property and you have disclosed it, but you have no documentation of the reports. You would check that box. Line 28 is for the buyer, and line 30 is also for the buyer. They would check one of the boxes if they have received reports of lead-based paint being in the property. They would check the other box if they have not received any reports of lead-based paint being in the property. 32D, the buyer would initial there saying they've received a pamphlet, Protect Your Family from Lead-Based Paint in Your Home. So the box on line 35, the buyer would check this if they plan to do a risk assessment of lead-based paint in the property. This would be at the buyer's expense, and they would have 10 calendar days after the binding agreement date from the purchase and sale agreement to have this done. Line 38, the buyer would check this box if they intend to waive the risk assessment. So if you're unsure if there's lead-based paint in your home, the buyer would have the right to do a risk assessment on that. But if they decline, they would check that box saying that they've waived the right to do a risk assessment of the lead-based paint. And then line 41 basically says that your listing agent, listing brokerage has basically told you your responsibility to disclose all this information to the buyer. Line 44 is the buyer's agent has informed the seller of the obligations and is aware of his or her responsibility to ensure compliance. So basically, it's everybody's responsibility to tell you that you have to disclose lead-based paint being in the property if you are aware of it. And then below this, everybody would sign off on this. You would sign off on it, the buyer would sign off on it, your listing agent would sign off on it, and the buyer's agent would sign off on it. And then it would have the listing agent's company's information, the listing agent's license number, the selling company, which would be the buyer's agent's brokerage company, and the buyer's agent's license number. So that's going to do it for today's video. I hope you got some value out of it. If you did, leave a like, which is quick, easy, and free, and subscribe to the channel because I plan on coming out with several more property tours in the near future. They may already be out. I'm not sure when this video is going to get posted, and more great real estate advice is also coming. So I hope you have a great day, and we'll see you in the next one.